Okay, this will be a brief summary of The Puzzle of Independence and Parliamentary Democracy in the Common Law World, a Canadian Perspective, by author Lorne Sossin. The thesis of this particular chapter is the concern of the executive branch acting on partisan motivations. So what are partisan motivations? This is where the executive leadership or the administrative branch of the government is exercising public powers in ways intended to benefit one party or one partisan perspective on public policy matters. Two ways of this partisan motivation concern taking shape here. One is through the exercise of executive discretion over appointments, and two is through the attempts directly or indirectly to influence the actions of executive agencies. So let's first talk about executive discretions over appointments. So these are some summarized pulls from this article here, from this chapter. So the Constitution does not constrain the executive's power to appoint judges and other adjudicators and regulators, nor does it constrain the process employed to make such appointments. The executive's discretionary appointment power is virtually unfettered in Canada. When exercising this discretion, the government is engaged in an application of public authority governed by administrative law. Only a patently unreasonable exercise of an appointment power would attract judicial interference, from the CUPE Ontario case. And it was also noted that such a judicial interference has not yet come from the Supreme Court. While a system of federal judicial advisory committees function in Canada, they engage only in a screening to determine competent candidates and play no role in the actual judicial selection process. And these committees can be altered by the federal government at any time, as opposed to the United States, where there's quite the process of review and selection. Administrative tribunals and executive agencies do not enjoy the constitutionally protected status of judicial independence. So judges get security of tenure until the age of 75, and appointees to administrative bodies typically serve fixed terms as set out in their governing statutes. And such statutes may even provide for the appointment of adjudicators at pleasure, which means they can be hired or fired at will. And this is from the Oceanport case. The legitimate instrument always available to government to interfere with independent administrative agencies, Parliament. Okay, secondly, let's look at the attempts to directly or to indirectly influence the actions of executive agencies. Those who are affected by the decisions of administrative bodies do not have a constitutional right to an independent decision maker, as do litigants who have their disputes adjudicated in courts. And the common law principles of procedural fairness, which include a measure of independence for administrative bodies modeled on judicial independence, can be negated by a clearly worded statute. That's from the Oceanport case. The fact that tribunals function in much the same way as a court suggests that it is appropriate for its members to have a high degree of independence from the executive branch. Also, the independence of administrative bodies does not extend to immunity from direction from those bodies that are given delegated authority by Parliament. Those two notes are from the Bell Canada case. Finally, in the common law jurisdictions outside of Canada, governments have approached administrative justice as a system. Tribunals, for example, enjoy a certain minimum set of appointment standards. The second and related trend in these jurisdictions is to treat administrative justice as a policy sphere, and one that's appropriate for independent review and recommendations. So that's outside of Canada, and that's how other countries have approached it. So could be some lessons or directions for us here in Canada in the future. Thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.